Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 3 of our new program entitled Combating Bias in the Medical Legal Evaluation. And I have a fascinating discussion for you today, one that I'm sure is going to blow your mind. And the reason that it's going to blow your mind is that the purpose of today's discussion is to cause you to stop what you're doing and stop and think a minute as to how your opinions and conclusions that you've offered in your medical legal reports over the months, years, decades, and over your entire career have been colored and influenced by bias, stereotyping, preconceived notions, assumptions, and ingrained attitudes, and how those opinions and conclusions adversely impact one or more of the parties involved in your case. And I'm speaking not just to you with this discussion, I'm speaking also to myself, because I admit that now that I've taken a look at how my own biases affect my opinions and conclusions, I found that it's true, And this is not a fault of mine, and this is not a fault of yours, and this is not a fault of ours as a profession, but it exists in our profession, and it exists in ourselves. And the purpose of this discussion is to help remove bias, to remove stereotyping, to remove assumptions, to remove discrimination from your opinions and conclusions in your reports, such that accurate workers' compensation benefits can be provided to all persons, regardless of race, regardless of gender, regardless of sexual orientation, regardless of religious affiliation, and regardless of nation of origin. And these things, and many others that I'm going to share with you today, color our opinions and conclusions, and we're working with the Division of Workers' Compensation to eradicate and eliminate those from our reporting. So I have a fascinating discussion for you today. And before we get into that, let's just review the purpose of this entire program. And that is to explain to you how the DWC's plan to combat bias in the medical legal evaluation and in the reporting of QMEs, how that's expected to impact you as a QME, first of all. And then if you can understand that, how it's going to impact you, if you can understand that, I want to share with you in this program how you can arrive at opinions and conclusions and how you can write your report free from bias. And we're going to start touching upon that. In other words, how to actually construct your report free from bias at the end of today's discussion, so that appropriate benefits can be provided for all persons. Because let me tell you, the unintended effect of bias, stereotyping, discrimination, the unintended effects of these deeply ingrained beliefs in all of us has as their effect providing for workers' compensation benefits that are inaccurate, and specifically that are less than the injured worker actually qualifies for if they could get an accurate opinion from us as the qualified medical evaluator. So all bias in the workers' compensation system has the unintended effect of providing workers' compensation benefits that are not accurate. And accuracy is the order of the day, and no party has any objection to opinions and conclusions from the qualified medical evaluator when those opinions and conclusions are accurate. So the purpose of this program is to improve the system, and is to improve the reporting of you as the qualified medical evaluator by ramping up and amping up the accuracy of your reporting, because it's all about accuracy. And when we hold biases, stereotypes, and discriminatory attitudes, it can only result in opinions and conclusions that are not accurate. Okay? So let's talk about where we've come from so far in this program. In session 1 of this program, we talked about the origin of the concern for bias in the medical legal evaluation, and this historically traced itself back to 2016 with the Page versus Perry Soto lawsuit, wherein 4 claimants, all either women or representing women, came forward to sue the Division of Workers' Compensation for what they described as bias and discrimination in the workers' compensation system against women. They were claiming gender bias against women, and they clearly demonstrated in their transcript, in their lawsuit transcript, how the system discriminates and provides for inaccurate workers' compensation benefits based upon assumptions and biases related to gender, specifically the female gender, and preconceived notions and misconceptions about female reproductive biology. So this was in 2016, and not much really came of this lawsuit because it was found to have been filed in the improper court. But still, the Division of Workers' Compensation took notice and was stunned by this, such that they have now, in 2021, have taken an active step toward ramping up in the war against bias in the medical legal evaluation. And then in session 2, we talked exactly about what is the Division of Workers' Compensation's plan to combat bias and eliminate bias from the face-to-face evaluation, and especially in the opinions and conclusions of the QME in the QME's report. And this is a very comprehensive, well thought out plan. I'm very impressed by it, and I can't believe that someone has come to the brilliant conclusion that bias is something that the Division of Workers' Compensation needs to work on with us as doctors from the point in time even before we sit for the QME competency examination, all the way through our career on an ongoing basis, working with us to remove bias, and then all the way to the terminus, the terminal endpoint of the doctor's career as a qualified medical evaluator. So the DWC has a plan for combating bias all along the life cycle of each of us as a qualified medical evaluator, and these are all codified in new proposed regulations that I fully expect to pass probably as soon as 1/1/22, January 1st, 2022, because all of the new proposed changes to the regulations represent positive improvements for the system, and except for some minor tweaking of the language of one or more of these codes of regulation, I fully expect all of these new proposed changes to the QME regulations, especially those that relate to anti-bias and anti-bias training, I fully expect all of those to be enacted into law, and I consider that a good thing. So in sessions 1 and sessions 2, we answered the question, does bias exist in the medical legal evaluation? And indeed, we confirmed, at least through the Page versus Perry Soto lawsuit, that bias, it not only exists, but it's rampant, it's omnipresent throughout the medical legal evaluation. So where does that bring us for today's session? For today's session, we're going to take a look at the next question along our journey towards eliminating bias in the medical legal evaluation. And now that we know, and now that we have confirmed that bias does indeed exist in the medical legal evaluation, we want to take a look at the question, yes, I'm talking about you in this discussion, are your opinions and conclusions influenced or impacted by your unconscious, implicit, and even your conscious biases? I'm going to help us together explore this concept to discover wherein we may have examples of either conscious or unconscious bias. And what I want to share with you today is going to be a tremendous exercise for you that will cause you to take a look at your opinions and conclusions and pick apart those opinions and conclusions and look at the sum and substance of those opinions and conclusions for the hidden nuggets, the hidden nucleus of bias around which those opinions and conclusions are based and shaped. So in order to do that, we're going to begin by defining bias. We're going to give it a definition so that we all are on common ground and on the same page as to what constitutes bias. And then we're going to take a look at some evidence and examples of bias in the medical legal evaluation so that you can see for yourself clearly and on first-hand experience how bias subtly and not so subtly manifests itself in the medical legal evaluation and in the provision of workers' compensation benefits that in some way, shape, or form are not accurate, and how that inaccuracy thereby harms one or more of the parties involved in the system. And again, just to reiterate, before we get into the discussion, the topics of today's discussion, the whole purpose of implementing these changes, this anti-bias training, is to improve the accuracy of the QME's opinions and conclusions. Okay? So with that as our introduction, let's begin by gaining a greater understanding of what exactly constitutes bias. Okay, so let's define bias. What is bias? How does bias impact our opinions and conclusions in our medical legal evaluation? Well, here we have a definition of bias from Wikipedia, and this is not the only definition of bias that you can find, but this is one definition that's accurate for our purposes and upon which we can at least begin to develop our understanding of bias and stereotyping. So according to Wikipedia, bias is the pre-reflective attribution, in other words, these attribution of particular qualities occur pre-reflective, meaning before you or I even take the time to think about what particular qualities we are attributing to a member of some social in or social out group. Okay, so let me define that again. According to Wikipedia, bias is the pre-reflective attribution of particular qualities by an individual, such as us, the qualified medical evaluator, to a member of some social in or out group. So with bias, we have an in group and we have an out group. So in the workers' compensation setting, and when considering the medical legal evaluation, what can you imagine could be, or who could you imagine could be some members of the in group? The in group. Well, certainly us as qualified medical evaluators, we consider ourselves to be the in group to begin with. Okay, we as qualified medical evaluators, we're part of the in group, but who else could be included in the in group? Well, that can depend. That can depend on your particular bias. So for example, if you have a bias in favor of injured workers and in favor of providing opinions and conclusions strongly in favor of the injured worker, regardless of the circumstance, you would include the injured worker in the in group. The applicant attorney could be considered to be part of the in group. And if those members are part of the in group, who could be considered part of the out group? The out group would be, for example, the claims administrator, or would be the defense attorney. Now, if your philosophy is different, if your philosophy is more oriented as a defense-oriented qualified medical evaluator than your in-group is going to include the claims administrator and the defense attorney, and the out group is going to include the injured worker and the applicant attorney. And regardless of where your philosophy lies, that can vary, of course, but that will impact and influence what members are included in the in-group and what members are included in the out-group. And then therefore bias is your pre-reflective attribution of particular qualities to a member of someone either in the in-group or the out-group. And I have several examples that I'm going to share with you about how we attribute particular qualities to the injured worker, how we attribute particular qualities to the claims administrator and the applicant attorney and the defense attorney, depending upon whether we consider them to be in our in-group or whether we consider them to be members of our out-group. Okay? So continuing with Wikipedia, they tell us that bias is a prejudice in favor of or against one thing, a person, a group. Those are the members that we consider to be the out group when we have a prejudice against a group or against persons. Those are the persons in the out group, compared with another, for example, the in group, usually in a way that's considered to be unfair. And this is the problem that the Division of Workers' Compensation is hoping to combat, and that is unfair opinions and conclusions from us as qualified medical evaluators that unfairly provide or deny benefits for one or more of the parties involved in the case. Wikipedia tells us that biases may be held by an individual, a group, or an institution, and these biases, such as those held by us as qualified medical evaluators, such as those held by applicant attorneys and defense attorneys, such as those held by claims administrators, can have negative consequences and they can have positive consequences, both of which are not accurate consequences. And I'm going to share with you a couple of examples to illustrate biases that resulted in negative consequences and biases that resulted in positive consequences. Okay? So with bias, we have a prejudice either in favor of or against a thing, a person, a group, or an institution. And those that are in our in-group, we tend to provide favoritism or opine or have prejudice in favor of members of the in-group, whereas members of the out-group are treated with opinions and conclusions prejudiced against the interests of the members of the out-group. So we have in-group favoritism and out-group negativity. Now, again, according to Wikipedia, Wikipedia tells us that social psychologists have long made the distinction between in-group favoritism and out-group negativity, where out-group negativity is the act of punishing or placing burdens upon the out-group. So let's just stop right there. In the workers' compensation setting and in the medical legal evaluation, can you imagine a scenario or a situation or a circumstance where the qualified medical evaluator provides for opinions and conclusions that creates a punishment or that places burdens on members of the out-group? Let's say that you are an applicant-oriented qualified medical evaluator and the claims administrator and the defense attorney are therefore members of the out-group. Okay? Is there a situation that you can imagine where your opinions and conclusions punish or place burdens upon the out-group, upon the claims administrator, upon the defense attorney? Of course, this happens all the time. And in reverse, if you're a defense-oriented qualified medical evaluator, can you imagine a situation or a scenario where your opinions and conclusions regarding the out-group, meaning the injured worker, and the applicant attorney punishes or places burdens upon those members of the out-group? And of course, this happens all the time, and I'm going to share with you some examples that you may have never considered that you are engaging in with each and every evaluation. And I'm not blaming you. I'm simply illustrating this principle to show how all of us as qualified medical evaluators, unfortunately, provide for opinions and conclusions that are not accurate, because of these ingrained and long-held biases that shape our opinions and conclusions. The Wikipedia continues on, and they tell us that indeed a significant body of research exists, and I'm going to share with you a couple of pieces of research today that attempt to identify the relationship between in-group favoritism and out-group negativity, as well as conditions. Conditions could also mean situations, could also mean circumstances that will lead to out-group negativity and also that will lead to in-group favoritism. And in the workers' compensation system that we are involved with, I'm going to share with you just some examples of some different conditions that could cause us as qualified medical evaluators to punish the out-group, whoever may be a member of that out-group. So with bias, we have the unintended consequence of in-group favoritism and out-group negativity. And again, quoting from Wikipedia, out-group negativity is the act of punishing or placing burdens upon the out-group. And so let's take a look at some of those possible punishments and burdens, and also some of the conditions that may lead to negativity in the work that we do as qualified medical evaluators. So if you're watching the video program, you'll see in front of you I have a table that lists some of the various members involved in each and every evaluation that we engage in. We have the examinee, we have the claims administrator, we have the applicant attorney, we have the defense attorney. And if you consider yourself to be an applicant-oriented qualified medical evaluator, then the examinee and the applicant attorney will both be members of your in-group. Okay, let's use blue to indicate the members of your in-group. So with in-group favoritism, you as the qualified medical evaluator may decide that your examinee is not permanent and stationary. This is a punishment against the members of the out-group, correct? So here's the claims administrator and the defense attorney as members of the out-group, and let's see how your out-group negativity can be biased to punish or place a burden on those out-group members. You may decide that the examinee is not permanent and stationary, and that additional diagnostic studies are needed, that the examinee qualifies for additional total temporary disability, and you may place punishments and burdens on the out-group, members of the out-group, that are very, very expensive, that cause tremendous delay in the resolution of the claim, and that place additional burdens, time-consuming and costly burdens between the examinee and the resolution of the case. Okay, so these are just some examples of punishments and or burdens on the members of the out group, such as the claims administrator and such as the applicant attorney, and conditions that could possibly lead to negativity or to out group negativity could be prior history with this particular claims administrator here, a prior negative experience with the claims administrator, such as perhaps failing to get paid timely on a prior case that you had with that claims administrator. I know one qualified medical evaluator colleague of mine that if the claims administrator takes any negative action toward him, he says nothing, but he retains that memory for the future, and in the future he goes out of his way to create an undue punishment and or burden on that particular claims administrator. Perhaps you've had some prior experience with this defense attorney, some prior experience with the claims administrator. These are just some examples. There may be many more other conditions that lead to negativity, but the point is, and the illustration here is to show how in the workers' compensation setting and the work that we do, how we place these punishments and these burdens, these costly, time-consuming, and expensive burdens on the members of the out group. Now, on the other hand, if you consider yourself to be a defense-oriented qualified medical evaluator, then the claims administrator and the defense attorney are members of your in-group, whereas the examinee and the applicant attorney would be considered members of your out-group. So how could you as the qualified medical evaluator burden or punish the examinee or the claims administrator? Well, if the case is a denied claim that involves a compensability evaluation, you may decide that there's no industrial injury and that the examinee is not entitled to any benefits under the workers' compensation system. In other words, no AOE, COE, no claim, no medical treatment, no temporary partial or temporary total disability. In the event of an accepted claim, if the examinee is a member of your out group, the applicant attorney is a member of your out group, you may opine for no impairment, no cherry on the pie, no pot of gold at the end of the rainbow. If the examinee is on work restrictions, medically prescribed work restrictions, you may decide to burden them, place a burden on them by sending them back to work with reduced work restrictions that cause them to have to work with more pain, or cause them to have to work harder, or cause them to have to do work that they do not want to do, that causes them increased injury, etc. And these are just examples of some of the different types of burdens that can be applied to the members of the outgroup. Okay? And conditions that can lead to this outgroup negativity includes prior history. Prior history with what? Prior history with same similar type of examinee. Maybe you had a prior history with this applicant attorney where this applicant attorney roasted you in a deposition. And now in an effort to get back due to bias, the attorney becomes a member of the dissimilar outgroup, your outgroup, for who becomes the target of punishments and burdens. Maybe you've had some prior experience with this same similar type of examinee. The examinee presents with a similar scenario, same story, looks the same, acts the same, smells the same, talks the same, creates the same deja vu experience in your long-term memory. And this prior experience, for which you had a bad taste in your mouth prior, causes you to place this examinee in your outgroup, being a dissimilar person, a person with dissimilar beliefs, dissimilar appearance, dissimilar language, dissimilar job duties, dissimilar level of education, dissimilar nation of origin, dissimilar gender, dissimilar sexual preference from you. And by virtue of being placed in this outgroup, as a member of the outgroup, becomes the victim of punishments and burdens due to outgroup negativity. So what is it that determines whether the examinee falls into a member of our in-group or a member of our out-group? What is it that determines whether or not the applicant attorney becomes a member of our in-group or out-group? Or how does that apply to the claims administrator, and how does that apply to the defense attorney? Well, the targets of bias that the Division of Workers' Compensation is attacking include race, gender, sexual orientation, or I should say sexual preference, religious affiliation, and nation of origin. So it's found that members of different races tend to fall in different social outgroups. When you as the qualified medical evaluator are sitting face-to-face with an examinee, and that examinee has a different sexual orientation or a different sexual preference from you as the qualified medical evaluator, you tend to bias that examinee by placing that examinee in your outgroup. When the injured worker has a different nation of origin than do you have a tendency, an unconscious bias, to place that injured worker in a member of your outgroup. So what is it about race? What is it about gender? What is it about sexual preference? What is it about religious affiliation that causes this unconscious bias, this unconscious positioning of this person, this group, this institution in either your in-group or your out-group? And much research has been done on this, and research indicates that the controlling factor has to do with beliefs, that each of these different out-group members have different beliefs from what you and what your members in the in-group operate under. And there is some research regarding this. This is what's referred to as the belief congruence theory. How congruent or how dissimilar are the beliefs of the members of the in-group compared to the beliefs of the members of the out-group. Now, Strzok and Schwartz tell us that the belief congruence theory concerns itself with the degree of similarity in beliefs, similarity in attitudes, similarity in values that are perceived. They may not be actual, but they're perceived to exist between individuals. This theory also states that dissimilarity of beliefs, dissimilarity of attitudes, dissimilarity of values increases negative orientations towards others. So with in-group favoritism, people who have similar beliefs as do we, they tend to receive favoritism, positive opinions and conclusions from the qualified medical evaluator, whereas persons who have dissimilar beliefs, we tend to have negative orientation, and we tend to provide opinions and conclusions that place burdens and or punishments on those persons. Now this is fascinating because this concept, this belief congruence theory, when applied to racial discrimination, okay, race is one of the targets of bias that the Division of Workers' Compensation is attacking. There's also other targets, but considering just racial discrimination, the belief congruence theory argues that perceived dissimilarity in beliefs has more of an impact on racial discrimination than does the race itself. So what this suggests is that persons of different races perceive that they have dissimilarity of beliefs. What about when this is applied to gender? When applied to gender discrimination, the opposite genders perceive dissimilarity of beliefs. What about when this is applied to sexual orientation? Sexual orientation argues that there are perceived dissimilarity of beliefs of persons of different sexual orientation, and it's this perceived dissimilarity of beliefs has more of an impact on racial discrimination than on the fact that the persons have different sexual orientations itself. So this is bias is largely based on the perception of the beliefs and attitudes and values that are held by one party compared to the other party. So let's take a look at how this could possibly play out in the medical legal evaluation. Okay, so imagine again that the examinee and the applicant attorney are members of your in-group because you consider yourself to be an applicant-oriented qualified medical evaluator. In that situation, these three persons, the qualified medical evaluator, the examinee, and the applicant attorney, have a similarity of beliefs that justify and direct all of their actions, all of their opinions, all of their conclusions. Some of those beliefs might be that insurance companies screw everyone. They screw everyone. The examinee believes this, applicant attorney believes this, you as the qualified medical evaluator believes this. This is going to impact your opinions and conclusions. You may also believe that employers hide injuries and they fail to report injuries. And if you believe this, this will impact the opinions and conclusions of your report. If you believe that the medical treatment that is rendered to injured workers in the California Workers' Compensation is terrible, it's substandard, it's incompetent, this will impact the opinions and conclusions in your report. These are similar beliefs held by the members of the in-group. Now, these beliefs, of course, contrast and are diametrically opposed to the beliefs of the members of the out-group, such as the claims administrator and the defense attorney. For example, that all injured worker claimants are fakers, they're all benefit seekers, they're scammers. We could give them medical treatment, but they're never ever going to get well, no matter what medical treatment we give them. And it's these opinions and conclusions that cause the actions of these parties in the system. Now, on the other hand, if the claims administrator and the defense attorney are members of your, these are members of your in-group, and in this case, the examinee and the applicant attorney are members of your out-group, how could the beliefs of the members of the in-group affect the opinions and conclusions of the qualified medical evaluator? Well, in this case, all of the in-group members, meaning the claims administrator, the defense attorney, the qualified medical evaluator, believe that all injured workers are exaggerators and malingerers and symptom magnifiers, and they all are polyclaim mongers in that they file multiple claims in addition to the workers' compensation claim, such as a wrongful termination claim or a disability claim or a subsequent injury fund claim. If you believe this to be the case, this of course will impact the opinions and conclusions to punish or place burdens on the members of the outgroup, in this case, the examinee. Now, if this is your particular orientation, that of being a defense-oriented qualified medical evaluator, your beliefs will be dissimilar to the beliefs of the members of the outgroup as regards to the need for benefits. Your beliefs will be dissimilar as to whether or not there is an injury or not, and you will be firm and resolute in your belief that there is no injury. Your beliefs will be dissimilar as to whether or not the injured worker needs to return to work, and you will believe strongly that the injured worker should return to work, which would be in diametric opposition to the beliefs of the members of the outgroup. Okay, so is this actually prevalent? Is in-group and out-group bias actually present in the workers' compensation system, or are these just interesting and rhetoric questions? Let's explore that a little bit in some venues outside of the workers' compensation system. Now, before we talk about in-group and out-group bias, meaning in-group favoritism and out-group negativity in the workers' compensation system, let's take a look at the potential presence or absence of these two factors, in-group favoritism and out-group negativity, in other forensic type settings and situations. So let's take a look at some studies that involve police investigations and another study that involves judicial decisions. And the conclusion is that research finds actual evidence of in-group bias in police investigations and in judicial decisions. So first I want to share with you a study entitled Racial Bias in Police Investigations. This is a study out of UC Santa Cruz, the conclusion of which is that I, meaning the author of the study, I find state police officers issue significantly more traffic citations to drivers whose race differs from their own. Different races create different outgroups between the police officer and the car driver, the driver of the vehicle. When they have different races, the police officer is more likely to issue a citation than when the two parties are of the same race. This bias is evident for both moving and non-moving violations, the latter indicating a preference for discriminatory leniency towards same-race individuals, same race. I show this treatment is unmitigated by socioeconomic factors. Officers cite other race drivers more frequently regardless of their age, regardless of their gender, regardless of the vehicle value, and regardless of the characteristics of the local community. So in this particular scenario in police investigations, the strong determinant factor that places individuals in different groups, different in-groups and different out-groups, has to do with race. And when there are different races involved, the person of authority, the police officer, similar to us as qualified medical evaluators being an authority, tends to opine with out-group negativity. Out-group negativity. Okay? So that's an example of bias in police investigations. What about in judicial decisions? Okay, now in this 2017 study entitled Judges, Juveniles, and In-Group Bias, published in the Journal of Law and Economics, we have a fascinating study because it shows for the first time how the person, again in authority, which in this case is the judges. In the last study we had police officers, and we're analogizing this to us as qualified medical evaluators as persons in authority who have medical decision-making power. So in this case, this deals with judges and their use of power in rendering opinions on juveniles who come before them in the court. And this is a fascinating study because typically we think of in-group and out-group bias as involving in-group favoritism, and we showed that with the police investigation study. Typically, bias involves in-group favoritism and out-group negativity. That's the typical scenario, but this is a study that shows the exact opposite. It shows in-group negativity. So it's an example that bias can be biased. Bias can go in either direction. And this is a fascinating study that for the first time shows an example exactly of that. So in this study, they investigated the existence of in-group bias, which involves preferential treatment, favoritism of one's own group in court decisions. So this study involved juvenile court cases in a United States state between 1996 and 2012. So here they were looking at juvenile court case decisions, and they investigated and they took a look at random assignment of juvenile defendants to judges. They found an evidence for negative racial in-group bias in judicial decisions, whereas judges and juveniles, when we had a black juvenile who was randomly assigned to a black judge, and the opposite situation presented itself as well, whereas white juveniles were randomly assigned to a white judge, they were more likely to be placed in custody. They were more likely to be put in jail as opposed to being placed on probation. And they received longer sentences. The in-group juvenile received a longer sentence than an out-group juvenile. So let's clarify this. When black juveniles came in front of black judges, they tend to be placed in jail more often than white juveniles who were being evaluated by black judges. Black juveniles being evaluated by black judges typically receive longer sentences than white juveniles evaluated by the same black judges, and vice versa for the race of the judges and vice versa for the race of the juveniles. Now they tell us that although this is observed in experimental settings, this is the first empirical evidence of a negative in-group bias. This is a first example of a negative in-group bias, and I present this to you here to illustrate that even with regards to bias, there is some bias, and we can't simply rely on one definition of bias involving in-group favoritism and out-group negativity. We have to be aware that it can go both ways, with both positive in-group bias and rarely examples of negative in-group bias as well. And this is something that we need to be aware of as qualified medical evaluators when we provide our opinions and conclusions, such that our opinions and conclusions are fair for all persons, regardless of where they fall in their similarity to us, whether that similarity be based on beliefs, whether it be based on race, sex, sexual orientation, gender, religious orientation, or nation of origin. So doctors, isn't that fascinating? We have evidence that in-group bias exists in police investigations, that it exists in court decisions, and through the Page versus Perry Soto lawsuit, we have evidence that in-group bias exists in the workers' compensation system. So in our next session, I want to share with you other evidences of in-group bias and discrimination and stereotyping in the workers' compensation system. And I want to share with you several case examples that illustrate how the opinions and conclusions of the qualified medical evaluator were shaped by long-held biases, long-held stereotypes, and ingrained assumptions about persons different from the qualified medical evaluator, and how those opinions and conclusions in the qualified medical evaluator's report resulted in workers' compensation benefits that were not accurate. Thus, the inaccurate opinions and conclusions caused detriment, caused hardship, caused punishment, and placed burden on one or more of the parties involved in the evaluation. Now, the overriding principle of this entire discussion and of all of the proposed new changes to the QME regulations is to improve the system. And the Division of Workers' Compensation intends to improve the system first by improving the content and quality of the Qualified Medical Evaluation Report such that the Qualified Medical Evaluator's report is accurate. Accuracy is the order of the day, and no party in the system has any problem whatsoever with your opinions and conclusions when they're accurate. Now, one or more of the parties may not like your opinions or conclusion. One or more of the parties may suffer great expense as a result of your opinions and conclusions. But I'm here to tell you, and I've learned this from all of the players in the system, that no one has any difficulty with opinions and conclusions that are accurate. The whole driving impetus behind the anti-bias training is to provide opinions and conclusions are accurate. And in our next session, I want to share with you exactly how you can start eliminating the impact and the effect of long-held biases upon your opinions and conclusions so that you can indeed render opinions and conclusions that are accurate. So doctors, I want to thank you for taking the time to join me on today's discussion. I look forward to being with you on our very next discussion as well. And for now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.